Good morning, everybody. Justice Pitley, in the audience, Justice Mai, our former Chief Justice of the Calcutta High Court, Justice Prakash Srivastav, who is now in charge of the Environmental Tribunal, the Apex Environmental Tribunal in India, and my co-panelist and everybody who has braved an early Sunday morning to join us for this session. I'll just take 5 minutes to indicate one aspect of this today's session. We know that the basic principle of rule of law is that law should govern and not anything other than law. But we take it a step further and we say that there are certain very primary principles which must be there for there to be rule of law. For instance, equality and other aspects. Now, rule of law is not rules of law. There are a million rules of law, but rule of law is not that. It is those principles, 3 or 4 of them, which are universally accepted. And every nation on earth at least tries to provide for it in their jurisprudential system. Now, perhaps the most important part of this discussion ought to be what are the corrective mechanisms available to ensure that the rule of law provisions which are embedded in every jurisprudential system are not given a go-by, or to bring the system back to where the rule of law is being followed. That's a very important principle which we have to look at nowadays. Now, sovereign debt was discussed in brief by our president, Mr. Prashant Kumar, yesterday. He was talking about sovereign debt and principles which are to be applied to it on a multilateral basis. That is, he was talking about how to ensure that sovereign debt is not dealt with in any unfair manner by the nations which have been responsible for lending. Today's session, at least on paper, subject to what my co-panelists would like to make of it, is more about how to handle it within a particular jurisdiction. When we talk about a multilateral problem, then of course we are looking for multilateral institutions, as Justice Petele just pointed out. Alternatively, there is another possibility, and that is, as more and more nations follow these principles of rule of law, then the approach of every nation is on the same page, and so therefore that is another method by which it can be brought about. As far as our constitution is concerned, and I'll just end with this thought, we have a constitution which provides for some of the principles of rule of law in a chapter on fundamental rights, like for instance the principle of equality. This is enforced by our courts and enforced rigidly. Now, sovereign debt and how to deal with it are matters of policy. By and large, it is well settled in our jurisprudence that policy matters are not to be gone into by courts. Courts do not review matters of policy. What has to be done is to see that the executive and the legislature whether they are following the principles of rule of law or not, but the court cannot intervene. However, we have another device in our constitution, a very interesting device, and that is a chapter called the Directive Principles of State Policy. And the Directive Principles of State Policy, while not enforceable in a court of law, are fundamental to the governance of this country. And those directive principles, please take a look at it at some stage, contain, particularly in Articles 38 and 39, several of the principles that we think are part of rule of law. For instance, the need to be fair in the equitable distribution of the resources of the country. Now, the directive principles are guidelines for the government and those who are governing it has also been utilized by our courts to give meaning to fundamental rights and other provisions of the Constitution. So even though the Constitution itself provides that it is not enforceable in a court of law, the courts have attempted to enforce it to some extent possible by using it to interpret and give content to other provisions of the Constitution. Now, with those words, I would like to hand it over to the panelists of the day. Thank you very much.